Application. Applications. Man, no, sir. This is an application.
You're mentioning upon notice. Please give a notice.
I have given the
No, which year? New
Which year?
filing.
25.
Please give a no. It appeared earlier.
No. This is the first time.
Well, at the same prayer, my lord, the application.
First time.
Lord, yesterday your lordship was pleased to make direction upon ourselves, Lord, to make an endeavor for obtaining the test score of the 12 candidates. Lord.
No. We have said we said list. Without we said you file. We have directed you
Yes.
to file a supplementary affidavit disclosing the roll numbers.
Yes, Lord, I have collected all their roll numbers along with the test score.
Very good.
All are in below. Lord, lordship, kindly place the matter under to be mentioned, Lord, any day. Lord,
Why?
before me, Lord.
We have kept it on 15th.
15th of January, Lord.
Yes, don't hurry. Make a supplementary affidavit. Give a copy to the other side. You will get the order today in the server.
Yes.
Please take the order. We have said that you will file a supplementary affidavit disclosing the roll number, so that if you say that you have got the marks also,
Yes.
mention that in the,
Bring it on record.
They are all
bring it on record.
they are all below.
Okay, bring it on record.
Yes.
Yes.
What you're mentioning for inclusion in the list.
Huh?
Inclusion in the list. Other side has been served.
How many matters here means?
Only one. But other parties have been served. These are service notices.
Service to the
Service to the respondents. We have served
that you will make anybody engaged on their behalf.
Lordship, no, I don't.
Application of which year?
2025.
First time appearing. First time it will appear.
For the second time.
So first time what happened?
First time it was dismissed for default, Your Lordship. And there was a
So they filed a restoration
Yes,
application.
Your Lordship.
So restoration application you are mentioned.
No, for inclusion in the list. It was appearing in the monthly list of November, and then in the monthly list of December, it was not appearing. Praying for inclusion in the December.
So why were you not there when the matter was called on?
Not engaged in that matter.
Your restoration has been allowed.
No, Your Lordship. It is pending.
Dekhe na to restoration. Yes.
Your Lordship, with your kind leave, may I file an appeal without a certified copy?
Why?
This is again, Your Lordship, we have applied for the certified copy on this Monday, and we have not obtained the copy yet.
When was the order passed?
Your Lordship, 4th December 2020, this year, 4th December.
What is the urgency, madam?
Your Lordship, my senior tried to mention this matter yesterday as well. This pertains to the creation of supernumerary posts, Your Lordship. We are the added respondents in the writ petition, and we are the waitlisted candidates who are supposed to be appointed by virtue of the notification.
Yes.
May I have under compelling circumstances?
Grateful, Your
Lord, I am
Lordship.
mentioning this matter. It is yesterday's matter, my lord. It was submitted that I have participated in the hearing and everything. My lord, I am handing up your lordship the.
Very good. We will check it out.
Kindly see once, my lord. On 8th, my lord, I have prayed for an adjournment by way of mail. On 8th, but it was not intimated whether the matter will be adjourned or not. Therefore, on 10th, I went personally yesterday and submitted once again the adjournment petition.
Very good. You mention it to us.
Yes, Lord. That is
Because
why
his
Lord, I am
submission, we have
mentioning
recorded.
it upon notice, my lord.
Very good. You place that before us when we
Because, Lord,
take it up.
your lordship can appreciate that it is a
Yes, call
attempt
the
to
list.
outreach the process of law, my lord.
This is not the procedure. We have heard you. We have fixed it. Whatever objection you have, we will hear.
Lordship will not be on 16th. So I am only beseeching if it can be taken up tomorrow, my lord.
Yes, call the list.
Wait, please, Your Lordship.
I will file a then supplementary affidavit with this purpose.
My lord, I am for the appellant.
And I'm for the University of Calcutta.
On the last occasions were pleased enough to, my lord, restore the appeal as well as it was dismissed for default. Now, my lord, there is one difficulty which I find, my lord, after going through the entire records. But perhaps, my lord, there was no stay application along with the memo of appeal.
It was there, my lord.
It was.
It was there.
It has been transferred brief. It is a transferred brief.
Yes, stay application.
My lord, what I can submit, my lord, whatever papers I had availed, my lord, I can submit. But, my lord, so far as the annexures, my lord, I am not
Well, I can hand up a copy, my lord, and he
Grateful, my lord.
can come back before your lordship.
But this is a case where the appellant, my lord, was upon emerging to be successful in Madhyamik and higher secondary, my lord. Thereafter, he had availed admission in the BA Honors English. But the difficulty arose, my lord, when he cleared his part 1 and part 2. Now, my lord, part 3 examination, perhaps the 5th paper, my lord, subject to correction, my lord, when he went to the examination center, he was late. In a hurried way, my lord, he entered, whereby from, my lord, the mobile phone, the cell phone was in his possession. So, my lord, this was detected. And now, my lord, your lordship sees also, my lord, that so far as the general clause which was there, my lord, if someone, a candidate is found to be in possession of a mobile phone, my lord, disciplinary proceeding will be initiated. But what happened, my lord, he was restricted and, my lord, the paper was cancelled. My lord, that challenging that order, my lord, of the single bench.
Page 67 is the impugned order, my lord.
What survives?
But what I tell you, lordship,
2014 examination.
correctly fallen from it. But what happens so far as this appellant is concerned, in the midst of while he was giving his examination, he got a job in Tata service. That is admitted. Now, my lord, so far as this mark sheet, which was ultimately, my lord, shows that
Now come to the ordered impugn. Place the ordered impugn.
yes,
28th of April 2014.
I'm so grateful, my lord. May I read it, my lord?
Yes.
As per direction, copy of the 6th paper is produced. I do not find any irregularity in making assessment by the concerned examiner. However, so far the cancellation of the examination where some allegations were there in 5th paper, I am not inclined to interfere with the matter. However, the university authorities are directed to allow the petitioner to appear at the next examination of 2014. The rate petition is thus disposed of. The college authority is directed to allow the petitioner to fill up the form of the examination 2014 and send the same to the university, and controller of examination is directed to issue admit card of 2014 examination in favor of the writ petitioner. Mr. Bari, the learned counsel appearing for the writ petitioner, is to communicate this order to the principal of the college and the controller of examination, and they are to act on it. Now, my lord, so far as 5th paper is concerned, my lord,
So what happened? Did you appear in the next examination?
yes, I had appeared.
2014 examination you appeared
6th paper I have appeared,
and you passed.
yes.
So what remains?
Now,
sister?
so far as the 5th paper, it was entirely cancelled. Now, my lord, the
Yes, but you have passed.
no.
After this order, he did not participate, subject to correction.
If you had participated, then you would have got the copy.
Now, my lord, the only thing which your lordships are
Nothing, Mr.
will look into, but this is a in respect of his career. My lord, the entire mark sheet, my lord, because this paper was cancelled, which is completely, my lord, in violation of the law.
No, we are asking. This is a 2014 order. Appeal is of 2014. You did not get any interim order. Matter was dismissed for default. What will be the utility in keeping the matter pending?
No, I'm correctly fallen from. I don't
Then
want
what was your prayer in the writ petition?
my prayer in the writ petition, my lord.
You are challenging an order of 4th of July
Yes,
2012.
yes.
Where
Lord,
is that?
Page 44, my lord. Ito.
Kindly takes paragraph A of the writ petition.
Page 44, my lord.
Prayer A.
Yes. 4th of July 2020.
Issued by the respondent number 5 in annexure P4,
Hmm.
the impugned recommendation of the respondent number 6 for cancellation of the paper 5 of the petitioner, the impugned order of cancellation of paper 5 as communicated by the respondent number 5, wide memo dated 17/8/2012 is annexure P6, and the impugned decision of the syndicate of the University of Calcutta at its meeting held on 14th of February 2013 as communicated wide memo dated 27th of February 2013 in annexure P18, and the impugned guidelines on the syndicate dated 11/6/2019.
Where is this 4th July?
Page 42, my lord.
Page 42 is this.
My lord, page 42 of the stay application, my lord.
Actually, it will be the internal page 29, if I'm not wrong.
State I যাক না সব কটা রয়েছে
I
তো
don't have a copy.
আরে you come here না, let us read together.
Yeah, you have not paginated also.
I'm so sorry, my lord. I tender my apology, my lord, because this is the transferred brief now, my lord. I have been only engaged yesterday.
It's annexure P4, my lord.
Page number
42. Could I hand up my copy, Miller?
No, no.
Not related.
This is to certify that one Mohammed Mijanur was.
ওটা না ওটা না এইটা যেখানে তোমাকে ডেকে পাঠিয়েছিল হচ্ছে to appear before the board of discipline.
Did you appear before the subcommittee?
Yes.
Yes, yes. Thereafter, page 43 and 44 is the order, Milord.
Next page is the order where I have been reported against.
Order is, Milord, 17th of August 2012.
16th of August.
16th of August.
17th, Milord. 16th, Milord, is, Milord, certify that exam.
It's the
Certifying that he
He appeared in pending.
What is space? Annex 17th August?
17th August,
He
Milord,
cannot read.
is the,
Anderson is directed to inform Mijanur. That is English. What paper?
Milord, this is the fifth paper. Milord, he was found to, Milord, having adopted unfair practice during the conduct of the fifth paper. And, Milord, it was reported against what is called RA.
Yes.
Milord, pursuant to which, Milord, the Board of Discipline has given him opportunity and passed an order cancelling the fifth paper.
Did he participate in that?
Absolutely, Milord. He
For
participated.
the subcommittee?
Yes, Milord.
Where do we find that?
Milord, my lord will find that this is a written page 43, my lord will find.
Has been reported against
Next, P5.
had been reported against.
No, she
He will be informed about as a
participate করেছে কিনা সেটাই বলছি. Which page you are saying?
No, Lord, I don't have a apparently no document to show that he has not participated. Nevertheless, that is not the allegation that national justice was deprived of or something like that. He simply said, Miller, the Board of Discipline, after affording opportunity, has passed this order, page 44, cancelling the fifth paper. Nothing much. So due course was for him to sit for the fifth paper in the next available opportunity and clear the same. He comes challenging this order at page 44, passed by the.
So in the 2014 examination, he was required to reappear for the fifth paper.
Fifth paper. That was punishment was limited to that.
No, where that is not the order of the authority, that is the order of the court.
50.
Did he appear in the fifth paper in 2014? No.
Milord, after this leave, after order he did not. Page 50, my lord, you kindly come to page 50.
What
He
is
said
it?
report.
Page 50 is what?
Now, this is, my lord, a reply to the RTI by the petitioner, which might show some light, my lord.
Which one?
Page 50.
Date of the memo. Give us, I don't have page initial.
Milord, it is P10, Milord.
6th of March.
6th March. I'm grateful, Milord. I'm sorry, Milord. Kindly turn the page, the answers, Milord, will find.
Where? Turn the page, it is his letter.
His letter?
Now, next page, 2000
P10.
has been.
P10, Milord. আবার ওই ডিক্টেশনে নিয়ে যাবো, এখানে তো রয়েছে এখানে কি দেখাচ্ছিস Roman 3, my lord, may I read it for? As per directions, such and such appeared before the said subcommittee and admitted the charge of possession of mobile phone, but denied the charge of using the same in the examination hall.
Yes, you appear.
Page?
Page 50.
50 of the writ petition. 50 of the writ petition, my lord. আমার পেতেও আছে।
Which annexure you're referring to?
You don't have a stay obligation, sir. তুমি আমার থেকে স্টে অ্যাপ্লিকেশন নিয়ে পরের দিন মামলাটা করবে তো।
এটা কি appear against it?
হ্যাঁ, actually, yes. The inquiry report. ও চেয়েছিল কি যেন
His report, my lord, with deepest respect, was never served upon.
কোনটা?
ইয়ে
Reports upon through.
You have annexed this in the writ petition.
Please try to understand what I'm trying to
I'm
do.
will- I understand
Not
little.
to jump
report
upon.
in respect of his query.
Yes. So much of enthusiasm is
You
not
know,
good for your health.
I appreciate. So concern of my health, I appreciate, truly.
At this stage, after playing,
What can we do at this stage, sir?
What I'm trying to, my lord, impress upon your lordship. So far as, my lord, this appellant is concerned, my lord, so far as this part of his career, my lord, now what has happened? If that mark sheet which reflects that this paper was cancelled, my lord, today, as on date, my lord, he is not jobless.
তারপরে
He cannot join any organization because this has reflected all.
So you committed the wrong. They have mentioned that you have done so, and so your career is hampered. Why didn't you appear in the fifth paper in the next
that,
exam?
that, my lord, I was not allowed to.
Where is that? What you are saying?
If my learned friend is trying to submit that I have not appeared, my lord, they should come up
So
with.
show us that you appeared in the 2000. Then you accepted the order.
I come back with the.
No, then you have accepted the order. If you say you appeared, then order nothing remains in appeal because that order has been acted upon. If you did not appear, we cannot at this stage give any direction, consequential direction.
But the
What order we will pass,
lordship
tell us?
takes, subject to correction. If a lordship takes the order of the single bench,
Yes,
there was a, my lord, liberty that rest of the papers, 6th, 7th, and 8th, I have appeared.
yes,
And my lord, marks were obtained also.
yes,
But so far as 5th paper, where the dispute started, my lord, that has been cancelled.
yes.
So I did not get the opportunity of appearing in that way. If your lordship.
Why? Court said that the cancellation I am not interfering, but the university will give him a chance to appear in the next examination. Read the order. College authority is directed to allow.
But it's subject to correction. Next examination, my lord, accordingly, compliance of the order of the single bench, I have appeared on the rest papers.
Rest papers you are not required to appear. The order, the paper in which you exam was cancelled, that supplementary examination you will give. So you did not appear.
Mr. Ahmed Kais arranged. You admitted that you are found in possession of a cell phone in examination hall when examination was going on, but you denied that you used it.
আপনি পেছনে গিয়ে বসুন, আপনি পেছনে
adopted
গিয়ে
any
বসুন,
unfair.
পেছনে গিয়ে বসুন, অ্যাডভোকেট সাহেবদের এখানে বসবেন না,
So it is a
ওইখানে গিয়ে বসুন।
We have given you an opportunity of hearing and have taken certain decision. Now, at this stage, whether it would be proper to sit in appeal over this decision. Now you challenge the same. Or the single bench, okay, I do not want to interfere with the cancellation of, but I am giving an opportunity, you appear. You didn't avail of that opportunity. In the meantime, 11 years have elapsed. It is not also known whether the syllabus has changed or not.
No, today, my lord, he cannot appear.
Examination
There is a regulation which says that one has to complete. That regulation is set in terms of the UGC's direction, which mandates that one has to complete all the pending examinations within a span of 10 years from registration. So 2008-7 registration, 2017 the registration lapses. Today, my lord, I'm afraid, my lord, nothing can be done. What could have been very easy a job, my lord, he has made it complicated for himself.
10 years valid থাকবে registration.
Correct. Because that opportunity was given. I must go down to
The
your lordship.
present appeal has been preferred.
Go down to your lordship's observation. That is there.
Challenging an order
নগদও করছে এরকম। নগদও করছে এরকম। I don't like it.
অন্যায়টা কি হয়েছে?
এই মহামহিম ধর্মপ্রচার এই মোস্ট আনফরচুনেট অ্যাপ্লিক্যান্টের হামুল সাবমিশন হলো আমি 10(3) মামলা ফাইল করেছিলাম রিভিউ জাজমেন্টের কনক্লুশন পার্টের পরিপ্রেক্ষিতে 10(3) মামলা ফাইল করেছিলাম সেই মামলায় মহামান্য
আসুন সেই জায়গাটায় আসুন। কোন ডিরেকশনের বলে এই অ্যাপ্লিকেশনটা ফাইল করেছেন? আসুন।
মহামান্য
58 পাতায়, আপনার অ্যাপ্লিকেশনের 58 পাতায়।
হ্যাঁ হ্যাঁ
আসুন আসুন।
এই ডিরেকশন মহামান্য বিচারপতি সৌমেন সেন আমাকে দিয়েছে।
সৌমেন সেন সাহেব কি বলেছিলেন? পেজ কি?
However,
হ্যাঁ,
however, this order shall not prevent the applicant to seek appropriate legal remedy in accordance with law. আমি এই solemn direction
এবার কথাটা বুঝুন। আপনার যেই রিভিউ অ্যাপ্লিকেশনে এই ডিরেকশনটা দিয়েছে,
রিভিউ তো নয়, রিভিউ হয়ে যাবার জাজমেন্ট হয়ে যাবার
আচ্ছা
পর।
রিভিউ হয়ে যাওয়ার পর এই যে ডিরেকশনটা দিয়েছে, এটা আপনাকে অন্য জায়গায় যেতে হবে। এই হাইকোর্টে আর এটা পুনর্শুনানি হতে পারে না, সেটা আপনিও বুঝতে পারছেন। আমরা যদি কোনো মামলা ডিসমিস করে দিই, ডিসমিস যদি বলি যে আপনার কাছে এই পথটা খোলা থাকবে অন্য কোনো ফোরামে গিয়ে অন্য কোনো মামলা করতে, কিন্তু আমাদের কাছে যে প্রসিডিংটা সেটা মৃত প্রসিডিং। আর আপনার এই রাইডারটা যেটা আপনি দেখাচ্ছেন সেটার ভিত্তিতে আপনার এই পুনরায় অ্যাপ্লিকেশন আমরা গ্রহণ করতে পারি না।
আমি
জিনিসটা বোঝার চেষ্টা করুন।
আমি এখন
আপনার
কোথায় যাব মহাশয়?
হ্যাঁ হ্যাঁ,
আমি এখন কোথায় যাব? 83 সাল থেকে মামলা করে যাচ্ছি, আমার রেগুলার
এটা তো আমরা আপনাকে অ্যাডভাইস করতে পারবো না কোথায় যাবেন। আনফরচুনেটলি এটা হয়েছে। আপনার মামলা বহু জজ সাহেব শুনেছেন, অনেক সময় দিয়ে শুনেছেন, চেষ্টা করেছেন আপনাকে কোনো রিলিফ দেওয়া যায় কিনা, কিন্তু একটা জায়গায় তো থামতে হয়। কিন্তু তাও জজ সাহেব বলেছে এই প্রসিডিং মানে হাইকোর্টের এই প্রসিডিং আপনি কম্পেনসেশন ক্লেম করতে পারেন যে আমাকে এরম ভাবে হ্যারাস করা হয়েছে,
করেছি এই
সেটা এখানে এন্টারটেইনড হতে পারে না। কি করব বলুন, আপনাকে তো আমরা সাহায্য করতে পারছি না।
আমি কোথায় যাব মহামহিম? আমার জীবনটা শেষ হতে চললো, আমি কোথায় যাব?
আমাদের তো আইন অনুযায়ী চলতে হবে।
আপনার যন্ত্রণা আমরা বুঝতে পারছি। আপনি 1980 সাল থেকে ফাইট করে আসছেন, তাই না?
1983 সাল থেকে।
হ্যাঁ
1983 সাল
হ্যাঁ,
এই
কিন্তু হারাধন আপনার জায়গায় ঢুকে গেছে।
অ্যাপিল জাজমেন্ট বলেছে আমার রেগুলারাইজেশন রাস্তা তৈরি করে দিয়েছে। অ্যাপিল জাজমেন্ট,
হ্যাঁ
অ্যাপিল জাজমেন্ট
হ্যাঁ
2015 সালে যেটা জাজমেন্ট হয়েছিল,
হ্যাঁ,
আমার রেগুলারাইজেশন রাস্তা তৈরি করে দিয়েছে।
আশা তৈরি করেনি, শুধু ওই অর্ডারটাকে, সেটা আপনার পেজ 42।
হ্যাঁ,
আপনার মামলার আপিলটা ডিসমিস করে দিয়েছিল। দেবব্রত বাবু, আপনাকে কোনো সাহায্য করা যেতে পারে। আপনাকে আমরা আনিয়েছি ফাইল বের করানোর জন্য, আপনার ডিপার্টমেন্টের লোককে ডেকে পাঠানো হয়েছিল যাতে আপনার মামলায় কিছু থাকে আমরা আপনাকে করতে পারি।
অ্যাপিল জাজমেন্টে বলে দিয়েছে জজ সাহেব, ইফ উই ইগনোর দ্য ডিলে টুডে and go back to 1982, we are not in a position to accede to appellant's prayer in the presence of Haradhan Mondal. বিএসসি পিওর সায়েন্স টিচার।
এইটার বিরুদ্ধে আপনি রিভিউ ফাইল করলেন,
হ্যাঁ।
তো রিভিউ কোর্টও আপনার
কারেকশন প্রেয়ার করেছি,
Pardon?
এইটা ভুল অবজারভেশন ছিল, এটার কারেকশন প্রেয়ার করেছি।
রাইট। আপনি এই হারাদন বাবু তো রিটায়ার করে গেছেন
হ্যাঁ।
2018-তে,
আঠে
2008-এ।
আঠে
আজকে আপনার বয়স কত?
70 বছর।
তাহলে আপনি 70 বছর বয়সে তো শিক্ষকের জায়গায়
না,
যেতে
না,
পারবেন?
না, ওই আমার প্রেয়ার না।
ওটা যদি প্রেয়ার না হয়ে থাকে, আপনি কি চাইতে পারেন? যে আমি এত বছর ধরে যে মামলা করলাম, আমাকে কম্পেনসেশন দেওয়া হোক। ম্যাক্সিমাম আপনি এটা বলতে পারেন, কিন্তু সেটা তো আমরা আপনাকে দিতে পারবো না। যেহেতু সেন সাহেব বলে গেছেন যে আপনার অন্য কোনো যদি পথ থাকে আপনি সেখানে যেতে পারেন।
আমি রিভিউ ফাইল করেছি।
সরি
correction
দেবব্রত
prayer।
বাবু, আমরা কিছু করতে পারছি না।
আমি এখন কোথায় যাব মহামহিম?
আপনি এটা পিটিশনটা উইথড্র করে নিতে পারেন, উইথড্র করে নিয়ে এক উকিল বাবুর সাথে পরামর্শ করতে পারেন। আমরা তো আপনাকে অ্যাডভাইস করতে পারবো না, না?
ডিরেকশনের পরিপ্রেক্ষিতে তো ক্যান্টু ফাইল করেছি।
আরে ডিরেকশনটা যেটা দিয়েছে, সেই ডিরেকশনের ভিত্তিতে আপনি যেই প্রসিডিংটা খারিজ হয়ে গেছে সেখানেই আবার দরখাস্ত করেছেন। আমাদের কাছে রিভিউটা পেন্ডিং নয়। আমরা যদি রিভিউটা বেঁচে থাকতো তাহলে নয় আপনি এই আর্গুমেন্টটা করতে পারেন যে জজ সাহেব রিভিউটা ডিসমিস করেননি, আমাকে পুনরায় একটা দরখাস্ত করে আসতে বলেছে। সেটা তো এখানে হয়নি।
উনি রেগুলেশন চেয়েছিলেন তো ওই জায়গায়।
The humble submission, review judgment এর conclusion পার্টে জজ সাহেব এইটা করেছেন, conclusion পার্ট তৈরি করেছেন। It is now well settled that যতক্ষণ না অর্ডার 47 গ্রাউন্ড
দেবব্রত বাবু, এটা কি উইথড্র করে আপনি অন্য কোথাও যাবেন, না আমরা আপনার এইটাও ডিসমিস করব?
আমি
আপনার মামলাটা আমরা খারিজ করে দিচ্ছি, সেই জন্য আপনাকে জিজ্ঞেস করছি। আপনি তো আইনত সব বুঝবেন না। এবার এটা আপনার চয়েস, আপনি যদি বলেন।
আমার হামুল সাবমিশনটা মহামহিমের সামনে প্লেস করছি। রিভিউ জাজমেন্টের কনক্লুশন পার্টে এটা বলে দেওয়া হয়েছে, যতক্ষণ না অর্ডার 47 রুল 1 অফ দ্য সিভিল প্রসিডিওর হচ্ছে এস্টাবলিশ হচ্ছে, দ্য রিভিউ অ্যাপ্লিকেশন উড নট বি এন্টারটেন। এই কনক্লুশনের পরিপ্রেক্ষিতে ক্যান্সি ফাইল করেছিলাম, যেটার
খারাপ কি বলেছে?
ডিরেকশন দিয়েছে। এই কনক্লুশনের পরিপ্রেক্ষিতে ক্যান্সি ফাইল করেছে, আর সেই জন্য
ওনাকে ওনার ইয়েতে ঢোকা যায়। আপনার বক্তব্য হচ্ছে আপনি অ্যাকচুয়ালি সেখানে কাজ করতেন, কিন্তু আপনার ইন্সপেকশন রিপোর্টও আপনার নাম আছে, কিন্তু আপনার জায়গায় যখন ওরা আপনার জায়গায় অন্য কারোর নাম দিয়ে তার অ্যাপয়েন্টমেন্ট দিয়ে দিয়েছে, তাকে রেগুলারাইজ করে দিয়েছে, আপনাকে করেনি। এই হচ্ছে আপনার আসল ব্যথা,
মামলা
আসল মাথা। আচ্ছা আপনি তো এবার শুনুন, আচ্ছা আপনি তো আর ওখানে গিয়ে চাকরি করেননি, তারপর কোনো কাজও করেননি। এখন আপনার রিটায়ারমেন্ট হয়ে গেছে, যে কাজ করেছে সে কাজ করে তার রিটায়ারমেন্ট বেনিফিট নিয়ে বাড়ি চলে গেছে।
কাজ করিনি মানে ধর্মাবতার।
আপনাকে করতে দেওয়া হয়নি, আপনি করার যোগ্য ছিলেন। হ্যাঁ হ্যাঁ জানি তো, আমি জানি, আমরা বুঝতে পেরেছি। এইবার শুনুন, যে কোনো কারণেই হোক আপনি ওখানে কাজ করেননি, এখন যে আপনার জায়গায় কাজ করেছে সে কাজ করে রিটায়ার করে তার পয়সা করে নিয়ে সে চলে গেছে, এখন আপনার 70 বছর বয়স, এখন কি এই অর্ডারটা দেওয়া হবে যে না আপনাকে দেওয়া উচিত ছিল কিন্তু এটা আপনার প্রতি অন্যায় হয়েছে, সুতরাং আপনি এখন আপনাকে ওইখানে মানে চাকরিতে আপনি যুক্ত হতেন, এইটা ধরে নিয়ে আপনার সমস্ত যা পাওনা গন্ডা দেওয়ার অর্ডার দেওয়া কি ঠিক হবে? আপনি ওই জন্য কোর্ট বললো যে আপনার প্রতি যদি অন্যায় হয়ে থাকে, আপনি যদি কোনো ক্ষতিপূরণ চান, সেই ক্ষতিপূরণের জন্য অন্য
আমি এই
এবার আপনার
That is the only difficulty. Can 3 has been dismissed, my lord, my lord.
এবার ক্ষতিপূরণ হচ্ছে সিভিল কোর্টে হয়, ক্ষতিপূরণের সাক্ষী সাবুত দিয়ে ঠিক হয় ক্ষতিপূরণ কত হবে, 3 টাকা না 5 টাকা কত হবে, সে ওই সিভিল কোর্টে হয়।
আমি পেনশন বেনিফিট ক্লিয়ার করেছি,
জান বুঝতে পেরেছি তো।
আজ আমি হতদরিদ্র হয়ে গেছি
হ্যাঁ,
অর্গানাইজার।
আপনি তো কাজও করেননি, কিছু করেননি, এখন কি গভর্নমেন্ট তো বলবে যে কাজ করেনি আমি কেন পয়সা দেবো?
আমাকে কাজ করতে দেওয়া
হ্যাঁ,
হয়
কাজ করতে দেওয়া হয়নি, ঠিকই তো, কাজ করতে দেওয়া হয়।
এই অ্যাপিল জাজমেন্ট।
তাহলে এখন ওই জন্য কোর্ট বলেছিল যে আপনি যদি মনে করেন যে আপনি ক্ষতিপূরণ পাবার যোগ্য, তাহলে সেই আপনাকে সিভিল কোর্টে যেতে হবে যে এই কারণে আমাকে কাজ করতে দেওয়া হয়নি, আমি কাজ পাইনি, আর তার জন্য আমি ক্ষতিপূরণ পাওয়ার হকদার, তাই জন্য আপনাকে সিভিল কোর্টে।
প্যারালাইসিস অবস্থায় আমার আর মামলা করার সামর্থ্য নেই আমার।
হাইকোর্টে এইখানে এই যে বেঞ্চটা যে বিচার আমরা এখানে করছি, আমরা ক্ষতিপূরণ দিতে পারবো না, ক্ষতিপূরণ 3 টাকা হবে না 5 টাকা হবে সেটা আমরা ঠিক করতে পারবো না, বুঝতে পেরেছেন?
আমি অ্যাপিল জাজমেন্টের উপর ডিপেন্ড করে মামলা ফাইল করেছি। অ্যাপিল জাজমেন্টে অবজারভেশন হয়েছে it is true that the appellant's case was delayed and তারপরে আবার অবজারভেশন তৈরি হয়েছে if we ignore the delay today and go back to 1982, we are not in a position to accede to appellant's prayer in the presence of BSc teacher Haradhan Mandal. In such event, we are constrained to observe the appellant's prayer cannot be exceeded to এই ভুলটা কারেকশন করে রিভিউ পিটিশন ফাইল করেছিলাম, যে কারণ যতক্ষণ না এই ভুলের কারেকশন হচ্ছে, হারাধন মন্ডল তো স্কুলে নেই, 2015 সালে জাজমেন্ট হয়েছে, 2008 সালে রিটায়ার হয়ে গেছে, 7 বছর। কিন্তু যে উকিল বাবু আমার মামলা করেছিলেন তিনি বলেছেন হ্যাঁ এখনো আছে। এই কারণে আমি রেকর্ড প্রডিউস করেছি, অ্যানেক্স করেছি যে হারাধন মন্ডল অলরেডি রিটায়ার হয়ে গেছে, সুতরাং এই ভুলটা কারেকশন করা হোক, আমাকে রেমেডি দেওয়া হোক। এইটাই আমি
ইন্সপেকশন রিপোর্টে আপনার নাম ছিল না হারাধন বাবুর নাম?
আমার নাম ছিল,
আপনার নাম ছিল
ইন্সপেকশন রিপোর্টে, ডিএলআইটি রিপোর্টে।
হ্যাঁ, ডিএলআইটি।
আমি এবং আরেকজন অর্গানাইজার টিচার গৌরাঙ্গ শাসমল, আমরা দুজন, মাত্র দুজনের নাম রেকর্ড হয়েছে 1980 সালের ইন্সপেকশন রিপোর্ট।
আচ্ছা,
তখন থেকে আমি কাজ করে যাচ্ছি।
কুলটাস কবে রেগুলারাইজ হয়েছিল?
1982 সাল থেকে।
82 সাল থেকে। হারাধন 82 সাল থেকেই কাজ করে যাচ্ছে?
তারও আগে থেকে।
হারাধন তার আগে থেকে?
তারও আগে থেকে। এই ভুলের কারেকশন ক্লিয়ার করে মহামহিম আমি রিভিউ পিটিশন ফাইল করেছিলাম এই ভুলটার জন্য। এই ভুলের কারেকশনের জন্য বারবার আমি মামলা করছি।
কি ভুলটা হয়েছিল?
এই ভুলটা হয়েছে হারাধন মন্ডল 2008 সালে রিটায়ার হয়ে গেছে, কিন্তু এখানে অবজারভেশন তৈরি হয়েছে we are not in a position to accede to।
তো আপনাকে চাকরিটা দেবে কি করে বলুন? এখন আপনার ফেভারে যদি আমরা ধরি, আমরা কি বলবো যে 70 বছর বয়স্ক ভদ্রলোক, ওনাকে এখন তুমি চাকরি দাও? তাহলে আপনি কি ক্লেম করতে পারেন? আপনার যে 70 বছরটা হলো তার পেছনে সরকার দায়ী ছিল, যেন সরকারই আপনাকে দেয়নি, তার জন্য আপনি ক্ষতিপূরণ চাইতে পারেন। জিনিসটা বুঝেও যদি আপনি ভাবছেন যদি আমি বুঝবো না, তাহলে আর আমাদের কিছু করণীয় নেই।
করেছি মহামহিম, আমি কোথায় যাব? আমার
কোথায় যাবেন সেটা আপনাকে উকিল বাবুর সাথে কথা বলতে হবে।
আমার কোনো উকিল তো নেই মহামহিম।
তাহলে আমরা কি করব বলুন?
আমি ইন পারসন।
আপনি এটা উইথড্র করে নিন, তাহলে আমরা অর্ডার দেব না আপনার বিরুদ্ধে। আপনি উইথড্র করে নিন, পিটিশনটা উইথড্র করে অ্যাপ্রোপ্রিয়েট কোর্টে যান, সেন সাহেবের যে অবজারভেশন আছে সেটা দেখিয়ে
try to understand the predicament of
my remedy
person appearing.
no,
But my lord, the
it
review
was-
petition, the then recalling of the order passed in review, everything has been dismissed. But only one thing which is troubling me, my lord, the order dated 17th of September, that is what is before your lordship. My lord, the can 3 has been dismissed. So how, my lord, can 2 has been filed in October 2023, my lord?
And
There is,
who has been filed in
my lord, he is making a submission that in
we are
compliance. My lord,
we have checked that up.
my lord, my lord,
Can 3 number which has been given,
my lord.
that petition was affirmed in the month of October 2023.
October 2023.
Just
My lord.
16th March 2023.
My lord.
That is Can 3.
My lord.
And Can 223, which the original record is not here, that copy which has been given by him, from that it appears that this Can 2 has been affirmed in October 2023.
Yes.
So March 23 affirmed application has been given number as Can 3 and October 23 given as Can 2, though it should be vice versa.
Yes, my lord. My lord. My lord.
Records reveal that in connection with
Thursday or Friday, if possible.
My lord, only one thing. In the meantime, may I get a copy of Can 2 because that is also not with me.
এই শোনো, এইটা আমার অফিস থেকে
Ascertain the file because maybe
yes.
inspection of the file. Inspection of the otherwise মানে
কিন্তু এক্সিকিউট ওকালতনামা সেটা নিয়ে নে না এটা ওকালতনামা কি আবার কি
And they will also
তাহলে কি
give
করে
a-
হবে
yes
আমি টেকনিক্যালি
But
let him
technically-
execute ওকালতনামা otherwise technically it is not possible.
It is not.
Oh, okay, okay.
My lord.
That technical aspect will be looking
First
to.
you ascertain whether
One of the junior malad ascertain the inspect the file. After inspection of the file, match with his document. If it is possible, that is something.
Okay.
I
3 copy
18th my lord,
করে দিয়ে দেবেন
18th my lord has to be mentioned, 18th has to be mentioned.
no, no, better get
মানে 1 week my
malad it will be if because it is a long
last week
case.
last week এ রাখিস না তাহলে after vacation
we keep it after vacation.
my lord.
Because
We are fixing a date and time.
And malad I will also try to ascertain because whatever over here that I will try to ascertain is if that type of situation, what to do. Cross the age limit, what to, whether any judgment in this regard or not.
2
Right.
3 6
7 ফাঁকা আছে আর
8 is the Thursday.
মানে 8 জানুয়ারি
8 January.
এই 8 জানুয়ারি অনেক কিছু অনেক
আছে না।
অনেক ভর্তি হয়ে গেছে কিনা দেখুন
ঠিক আছে
মানে এটা নিলে মাথা ধরে
জেরক্স করছে ঠিক আছে আপনাকে কোনো কিছু করতে করতে হবে না। সমস্ত ডকুমেন্ট গুলো জেরক্স করছে ঠিক
8
আছে
জানুয়ারি কি অনেকগুলো আছে না 7 কম
আপনি
আছে না
ফাইল আপনার কাছে রাখুন
হ্যাঁ
সাথে কম আছে।
সব ডকুমেন্ট জেরক্স করে
তাহলে
দিচ্ছে
7th January করে
ওই
File.
ফাইলের
7 জানুয়ারি
সব কিছু
আমি
করে দেবো
7th
ঠিক আছে আমি করে দেবো আপনি আসুন আমার আমি করে দেবো আপনাকে আপনি দাঁড়িয়ে থাকবেন আমি করে দেবো My lord, last order, my lord. I ascertain whether that, sorry. My lord, take my lord, last order. Look at that. Oh. Last order. এই supplementary request কি? ও ডেটের ওই এভাবে বলে ডেটটা ফুল রং রেকর্ডিং বলে ওকে
এটা হচ্ছে ও ইয়েতে 10 বছর পরে চাকরি পেয়েছে মামলা করে এখন সে চাই
I take instruction from my client whether on that particular date or any representation or not. He says that kindly turn page number 59. 59 and 61. These two representation, but one of the date is wrongly mentioned. Specifically page number 59. An original representation, that is page number 56. And this is a typed copy. Page number 50. 56 is original one, but it is not readable, not legible. That's why, my lord, page number 59 is the typed copy, my lord.
What is the matter?
My lord, is that notional benefit, my lord. In the year 2001, a notification floated.
Now, after Justice Joyanto Biswas's order.
Yes, my lord. I got appointment, my lord. That order is annexed with my petition page, sorry, this appeal, my lord. Page number 51.
Page 50.
Yes.
Justice Biswas rejected your case.
No. Absence of discharge order, my lord, I got appointment.
For the state.
I'm late by Mr. Chakra.
By virtue Justice Biswas page 55 says that for the dismiss
It is filed by the one Sham Sundar Ta.
What?
He was overage. Election processes.
I was a party there on.
It was given
as a party respondent.
He served
There's several proceedings,
10 years.
multiplicity of proceedings. I just put
this
a little bit kind enough.
Cottage, what is
Yes. Kindly turn the reason order. In pursuance of that, I filed the petition, that is reason order annex page number 69. In brief manner, kindly turn page number 69. The last date.
12.
Then when did you get appointed?
2012. 13 August 2012, I joined in. Kindly turn page number 69. The reason order. I challenge this reason order in the way of writ petition, my lord. And
Reason order claiming what?
claiming 10 years continuous benefit.
So you entered in 2012.
Yes, but ought to enter in the 2002 because that Shamsun Datta continued his service from 2002 to 2012. So although, my lord, my appointment ought to be from that date. So that's my claim.
Now, why did the rejection order is that?
Page number 69. Kindly turn page number 69. It will give the clear picture.
69.
Rejection order by the TI. May I read one?
When did you return?
25 April
2025. Date.
69. Yes.
May I read one? Pursuant to the order of the Honorable Justice Rajiv Sharma passed on 22/11/2016, hearing was held on such and such date at the office chamber of the undersigned. Petitioner Sushil Kumar Roy and teacher in charge of Naupada High School, Srimati Moushumi Mondal, were present at the time of hearing. Honorable Court was pleased to direct to the respondent number 3 to dispose of the present dated such and such and such and such, which were annexed as annexure P4 and P5. That February 11 date is wrongly recorded. It ought to be the November. And the next one is right, or to the writ petition. If the same have not been decided as yet, if he is eligible for the same benefit that be paid, provided there is no legal impediment within a period of 3 months from the date of furnishing certified copy of the order after verification of the relevant document in accordance with law. Petitioner and the teacher in charge were heard and representation dated February, that would be November 11, 2014 and April 1, 2015. Where are taken into consideration on verification, it is found that petitioner got appointment on the strength of an honorable court order dated 17 August 2012, passed by his lordship Honorable Justice Jayanti Mishra by yes, my lord. Yes,
My lord, I am stopping my learned friend on the last occasion. There is specific direction of your lordship to produce the judgment of the division bench presided over Justice Kollanjyoti Sengupta, and as well as the PPO, pension payment order.
Two things, my lord. Pension payment order not yet, my lord. Did not get it.
Oh, March.
And the representation. 3. My lord, I have not got any.
30 June 2025.
30th June 25. So then why PPO not issued?
No, Steel has not retired. Steel has not retired.
Not retired.
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 30 June 2025.
Retired.
My instruction is that, because my client is present, he says due to overdrawn.
Overdrawn.
Although the pay scale was given, but the increment is not given. Pay scale is given, and now they says you are not entitled to that pay scale. Most probably, if I am not wrong. So that's why. So it's shown overdrawn only, because nowadays, my lord, in IOMS portal, my lord, it's just shown the overdrawn.
However, I don't understand. Because
that's the complexity of this matter. That is the complexity of the matter. Because of that, my lord, notional. If
you have to understand the case.
Yes. I understood, my lord. What happened, my lord? At that point of time, he ought to get appointment from the year 2002. But once Samson Datta got appointment in the year 2002. From 2002 to 2012, Samson Datta was in service by the dint of an interim order, my lord. Thereafter, my lord, Honorable Justice Jayanti Mishra passed the order. By the dint of that order, this person, Sushil Kumar Rai, got appointment and joined in the post in the year 2012, my lord. And in place of that Samson Datta. So, my lord, his candidatureship as well as his appointment ought to consider from the year 2002.
That we have understood,
yes.
What they did, the authority did, my lord, authority gave them the pay scale, matching pay scale of Samson Datta.
Oh, I see.
Matching pay scale of Samson Datta, but not give the benefit of annual increment. And not give the benefit of the seniority. Due to pay, he says, now our department says, you are not entitled that.
Department of Gas Order. এইটার জন্য বলা হয়েছিল এইটা।
That is why
in page 59. In page 59,
yes,
your client claimed that the Honorable Justice Kollanjyoti Sengupta and Asif Kumar Mondol to give same pay scale or
yes, till that matter I not got hold of that order.
Division bench
that's the
division bench order.
You have brought that justice.
No, I not get it. I posted it somewhere because he is not able to give it. My clerk try to hold up it.
The main crux of the matter held on the order of the division bench.
Yes, two problems will be solved.
But
They claim that you are erroneously enjoying the space skill.
No.
even if that,
If it is so, my lord, it cannot be sustained. If it is so,
Yes.
if it is so, it cannot.
Also,
yes,
everything will be solved.
yes.
They give same scale.
Some point of argument is there, man. Some point of argument is there. My lord, kindly, if you is
Got earlier ordered dated 25th November 2025, comma, dated the appellant
Yes, Lord.
Correction.
What correction? It's come for correction.
My lord, how it has come, I don't know. At whose instance? Not at our instance.
তাহলে অফিসের ইনস্ট্যান্স কেন এসছে তন্ময়বাবু?
Lord, in item number 5, my lord, may I be permitted to join virtually, my lord? I appear for the respondent, writ petitioner.
But the matter is appearing under the edit we mentioned because of the court last occasion wanted to know whether the writ petitioner should be allowed to continue render his service
Hello.
in the governing body, my lord. Now, whether the
Lord.
petition should be allowed, can be allowed to continue service in a primary school or not. That was
My lord,
the
may I clarify, my lord? Your lordship was of the opinion whether there can be. My lord, because I would not have been able to reach court in time because of a family, my lord, something happened, bereavement in the family. I had to go to, my lord, last
Now,
night.
tell us what we have.
My lord, it was posted under to be mentioned only for the purpose, my lord, your lordships were of the opinion whether the petitioner could be absorbed in any other school which is being run by the Bharat Sevashram Sangha or not, whether there is a possibility of any settlement being arrived at between the parties. They were to inform the court whether it was at all possible or not. The appellant.
instruction, he should be allowed to continue service
He will be allowed
in primary section.
in primary section
Yes,
of which school?
Under the Bharat Sevashram Sangha.
No. Presently, he was in which school?
Primary school.
Primary school? Where?
Not the Vidyapit.
Where?
At Beldanga.
Beldanga.
District Murshidabad.
So you will allow him to continue there?
In primary section, my lord. Petitioner was appointed in a secondary school, which is a girls' school. At the time of appointment, my lord, it is a private school, my lord, run by the Bharat Sevashram Sangha. Thereafter, petitioner was asked to change his school from secondary to primary, and he joined there. Thereafter, he claimed in this petition that he should be allowed to continue service in a secondary school, which is not possible because the school is a girls' school, my lord.
Oh, I see. So single judge directed appoint him in that secondary section.
Yes, my single.
That is why you come up in appeal.
Yes. I school was unpresented below before this.
That is separate thing. What will be the difference in salary then?
Salary, my lord.
So what do you say? You are ready to accept that?
My lord, factually, my lord, I beg to differ with my learned co-counsel, my lord, because, my lord, the case was not that. I was in service in the secondary school. I was removed unceremoniously. I was not allowed to participate.
Now, are you willing to accept the
my lord, then kindly gives me time. I will come back with the instructions because I cannot say I have to take instruction from the client because this proposal came for the first time today.
All right. Tell us when can you come? Tell us.
One day. one-day accommodation. Gives it tomorrow. Will come.
Thursday. Yes.
To be mentioned, madam.
To be mentioned next Thursday. And
Great.
it will be better if you can primary post, school address, and check up what will be the salary difference.
Yes.
Whether there will be any salary difference.
Salary.
Yes. I shall.
If
Great.
there is no difference in salary, then we can ask him that to accept the same to solve the problem. But if it is salary difference, he might say that
But he accepted the salary of the primary section.
forget about that. Now we are asking him.
Yes,
na.
madam. I
Yes.
shall.
That
I
will be punishment.
That Mr. Banerjee will decide or talk with his client.
Yes.
Definitely. Definitely.
Yes, next.
Grateful. Yes.
But,
সেটা নিয়েই চলছে। Yes, Mr. Bhattacharya, you brought the resolution.
Yes, but your lordship is aware of everything. But on the last day, your lordship asked for the resolution copy empowering me to prefer this appeal. This is the resolution.
No, we were asking whether there was any resolution that we will see. Where
Can I
did
just-
your
Lordship.
Challenge.
to challenge that
Board
board decision, was there any resolution?
No. I told no.
Acha.
The only decision is that, we are not affected. It is
Then
the
why
government
you are standing in the way?
It is the government money. Person having a fake certificate will take the money.
What government money has been taken away?
The B.Ed money, the B.Ed scale.
He has been given the MA pay scale, not the trained pay scale.
No, trained pay scale also.
6,000, 12,000. 6,000, 12,000.
Kindly have a look.
You see the approval memo?
The B.Ed scale also given.
No, that you have not said. Kindly come to page 49, Mr.
My lord, stand of the DI, may I submit? Stand of the DI.
Wait, sir, why your people are so impatient, I don't know.
No, but
He is making one submission. Don't interrupt.
Lords.
Yes.
Page 49, Malad, I am so grateful to your lordship, Malad. Durga Charan Ghosh, MA Bengali B.Ed with Sanskrit at degree level 80.
Yes. Now see the pay scale.
6,000 to 12,000.
So this, he has got the MA pay scale, not the trained MA pay scale. If he had, I do not know, that may be clarified.
State can say, Malad, I being the school, how can I say?
No, you are saying that this is government money taken away.
Yes.
If B.Ed degree is construed to be, suppose, accepting your condition that it is a false degree, does it disentitle him from carrying on service in that post? Because B.Ed was not a compulsory education.
Yes,
preferably B.Ed.
Preferably B.Ed.
So, if a person does not have B.Ed, he may also contest. But in his case, it's a unique case. He was the only one man there.
Yes.
But so far, the 6,000, 12,000 scale, I think it is for master degree pay scale.
But the state can apprise your lordship, Malad, whether he got the B.Ed scale or when.
Yes, show us the.
Yes, my lord, stand of the DI, my lord, I am showing. After the order of the honorable single bench, my lord, DI is repeatedly requesting.
Let us see.
Yes, it to be.
কপি দিবি?
এই আমার কাছে এই তোমাকে কমিউনিকেট করছে, তোমাকে অ্যাড্রেস করেই দিয়েছে দাদা। They have given reminder twice to the school office.
In compliance of the order.
Pension paper, naturally.
Even after filing of the appeal.
47.
You kindly come to page 39.
39.
See the qualification.
MA Bengali with Sanskrit at degree level and preferably trained.
So where it is said that B.Ed is compulsory.
The advertisement. This is the advertisement.
But the B.Ed degree was taken into consideration. Page 47.
That
I have only one line submission before your lords. But if he has taken the B.Ed scale, that is bad in law because the degree is fake. Only this much.
So for that, Mr. Bhattacharya, you intimated this fact to the board by your representation of 23rd December. 23rd December, your headmaster writes the letter saying that we have sent it these copies for verification to such and such person. Kindly come. This is not supported by any resolution of the managing committee. We do not know because you are simply a party in the writ petition. You did not get chance to file your opposition.
No. On the very first day, the order was passed.
Naturally, because if this is a representation of the headmaster, he writes that কিন্তু উনি ওনার চাকরির ইন্টারভিউর সময় বিএড এর মার্কশিট বিদ্যালয়ে জমা দিয়েছিলেন তাহার রাঁচি ইউনিভার্সিটি ভেরিফিকেশন করতে পাঠানো হয়েছিল দেন হু টুক দি ডিসিশন 23rd December দেন রাঁচিতে পাঠানো হয়েছিল তাহলে দ্যাট দেয়ার মাস্ট বি আ রেজলিউশন অফ দি ম্যানেজিং কমিটি দ্যাট আই হ্যাভ সিন দিস ইজ মাই রেজলিউশন অ্যাপ্রোচ দি কমিটি অ্যাপ্রোচ দি ইউনিভার্সিটি.
For every single work of the headmaster, the resolution of the managing committee is not required. He is the secretary himself. To file the case, I need the resolution, which I have. But to ascertain whether the document is fake or not, I being the head of the institution, I am preparing the service book of the person. I have every right to inquire. Because at the end of the day, the DI will stop my salary. Then why you have not checked the records and you have sent it?
So you are standing in the way thinking that if I allow this, my pension will be stopped. That is your apprehension.
A fake certificate has been produced. It is admitted. The documents are before the court. But on the very first day the order was passed, I could not get any chance to produce these documents.
The present appeal has been Report. What is that, Mr. Report?
These reports, my lord, were filed before the Lana single judge, my lord, the all justice Kosi Chando. On the last occasion, my lord, your lordship, my lord.
Yes.
The report. This is a report filed by the CID, my lord, in connection with those two writ petitions.
ওটাই তো বলে দিল চোখে। Oh,
No, there are two reports, two writ petitions were disposed of by Justice Otto, by Justice Kosi Chando. In those two
have gone through it.
Yes. Although, my lord, we have not preferred any appeal against that order, or my lord, we have not filed any exception to this report, because if your lordship kindly finds in the report that, my lord, we don't have any documents in relation to of those two cases. We didn't have any documents
In respect of those
those two cases. My lord, facts are dissimilar, because here, my lord, they say on the after post in the they opted for review. In the post publication review, they have been told that their marks were increased. That is the averment in the writ petition. Thereafter, ultimately, in the review process, their marks were increased.
Same year.
No. Milord, and Milord, in that those two cases, here, Milord, marks were increased through Milord RTI. Through RTI. That is through RTI. Marks were increased. Milord, marks cannot be increased through RTI.
RTI, yes. Review process is there.
Review, Milord, two ways of modus operandi at that point of time was operating. First, Milord, within the review period, apply for the review, then the marks increased.
No, then Mr. Moitro, if you say that the certificate is not a certificate found on the records, that is your stand. You have
documents the documents which have been called for from the university by the CID inspector, that none of the documents were with us.
So same thing is applying here. Here also you don't have any documents.
But we do not know, Milord. Here, Milord, they have applied for the Milord answer script through RTI. They have got the answer script, and modus operandi is this, Milord. Some marks were answers to the answer script marks were not given, and that marks were carried to their original total. And here, Milord, they say on the basis of post review process, after the review result, their marks were increased. Facts are dissimilar. One fact is very similar. In both the cases, Milord, they have come after 9 years. When, Milord, the employer asks for the Milord certificate of the university, then they only applied before the university to get the Milord certificate.
Same period. RTI নম্বর দেখেছে বলে কৌশিক চন্দ্রের অর্ডারটা দেখেছো?
Lord, I have cited two, Milord, in similar facts and circumstances, identical matters. One judgment passed by the Milord.
No, facts are absolutely different.
Milord, one একটু বলে নি, তুই বলো
বলেছো
আমি বলে দিই এটা।
আমাদের কাছে নেই।
হ্যাঁ, এই সার্টিফিকেট নেই।
মার্কশিটটা তাহলে অরিজিনাল খাতাতে এখন অরিজিনাল খাতা placed upon
two judgments, one by coordinate bench, another appeal carried out over the decision of the coordinate bench.
All right, Mr. Moitu, you have got the copy of this, na?
Yes.
We have just now got it.
Lordship, Milord.
Let us go through it.
Lordship, Milord.
Milord, may I just point out one thing? This is, Milord, in respect of the same period. Milord, in those cases, Milord, what happened, Milord? Milord, after, Milord, they applied for an answer script through RTI. They got the answer script, Milord, it was produced, and subsequently their marks were enhanced.
That was in review?
No.
That was after obtaining, Milord, answer script, they applied for review, and it was marks was enhanced, Milord, by exercising review power. Here in this case, Milord, what happened, Milord? I applied for review. Milord, I deposited the money. Thereafter, Milord, subsequently mark sheet was issued.
Showing enhancement.
Showing enhancement.
But they are saying that mark sheet is not there in
Yes,
their
database
This is
record.
their
This is
story.
their stand, Milord. They are saying, Milord, no document is available. They are not saying that marks. They are saying, Milord, simply the one number is not there. That's why it is fake. But number is very much there. They have annexed some document. Can you take, Milord, two documents? Will I just show to your Lordship? In their opposition, Milord, what they are saying that. Can you have a look, Milord, just to refresh your Lordship's memory, Milord? I am just placing it. What they are saying, Milord, that this mark sheet that is appearing at, Milord, page 20 of the opposition.
Yes, we have seen that.
They are saying it is fake as because there is no number. Because they know, but on the last occasion,
Mr. Tiwari, you have gone through it. What is the difference between that case and this case?
That case is in respect of, Milord, they applied for, Milord, answer script.
Same year.
Same year. More
Same
or less,
examination.
It is, Milord, 2012, 13, 14. Milord, in this period, Milord, all these things happen. That is in respect of 2012.
So he applied for review in this case?
In this case, Milord, applied for review in 2014, 15.
But nothing was intimated.
Nothing was intimated.
Herein is different.
No,
case is
that is not the correct situation. They have applied for post-publication review. We intimated them because there is no change in the review.
Those two cases.
These two, in this instant matter.
Here you said that no enhancement. So the
on those two cases,
certificate.
after the expiry of the review period, they applied to the RTI, got the answer script, and thereafter they say that certain marks were not added to the original marks, Group A or Group B.
So, that case also review was applied for, but as the marks were not intimated, they made an RTI.
They have not opted for review at all. After the expiry of the review, only one course left open to them to apply through RTI and get the answer scripts.
So how, if your record is not there, how did you give the information RTI?
They have got these. They have got the answer scripts.
They supplied the answer script. Can you see in the report? In the report, can you see?
Examination.
They supplied the answer script.
One thing, your Lordship. Kindly keeps in mind.
Before Justice Chandra, Milord.
When was the
date petition file 2017?
This is, Milord, kindly takes, Milord, report once. Kindly takes, Milord, first one. That is, Milord, in respect of Ashish Prasad.
Yes.
Kindly takes, Milord, conclusion portion. Page 6 of the report.
Serial number, dated post review as submitted by you. File letter such is not matching with the record.
Person.
Probably not, in terms of the statute, we keep answer script for 6 months. Thereafter it is destroyed.
Pardon.
We keep answer script according to in terms of the statute for 6
Yes,
months.
we know that.
Yes.
There is a time bar. We cannot force you. We are asking you as to whether is it able.
Let me take instruction whether their answer scripts are available or not. I don't think their answer scripts are available.
This is a special case. At that time, inquiry was going on for these 3 years.
Milord, your lordship would be astonished to find, Milord, I have annexed in my affidavit in opposition the charge sheet which was
What we
filed
are
against the
saying, Mr.
officer.
Mishra, we have understood your content, sir. In Justice Chando's order, there was a willingness on your part that yes, this was the disputed period, problem has occurred, all right, we will do it. So if you have done it in respect of a person pertaining to the
Milord,
disputed
then
period,
floodgate would open, Milord.
That cannot be
Floodgate would
done.
open, Milord. The thousands of students who has passed during those periods, Milord.
who were responsible for opening the floodgate? You did not prefer any appeal against that order. On the contrary, you voluntarily said it was not court's order. You said, oh, my lord, keep it, I will do it. You did it.
Milord, yes, Milord,
Please see the wording where what has been used in the order.
Milord,
University voluntarily says that, yes, I will.
Milord, when these cases start,
Then naturally, you are leaving a scope for persons to come and to disturb you again.
Milord, kindly takes those two Milord orders which I have annexed with my in my affidavit in
That is
opposition.
another. That is the problem. In one case, you are taking one stand. In another
Both
case,
the Milord, in that cases, Milord, in that case we have taken also that stand.
That's absolutely different, Milord, in those cases. Absolutely different.
pursuant to our earlier order, Mr. Yeah. Sorry,
Where is
vigilance.
My lord, I have applied.
Tomorrow.
My lord, very urgent, my lord. The license is going to expire, my lord, and the learned single judge, my lord, has not extended the license, my lord. It is going to expire shortly, my lord. Not my fault, my lord. I took the license out, my lord, in the month of July.
Yes, call the.
Grateful, my lord. Much obliged, my lord.
হ্যাঁ ওটা একটা কল করে দাও
একটা অর্ডার লিখুন ওই নন অ্যাপিয়ার্স
না একবার কল করে দাও
22 23 24 5 26 27 28 29 30 31 32 33 4 35 36 37
রিড করতে তো সবসময় রুল ইস্যু হয়ে যেত অ্যাডমিট হয়ে ফাইলটা না দেখে করা ডিফিকাল্ট
ফাইল দেখতে
প্লেস তো করবে তো সই করতে যখন প্লেস করবে তখন তো তোমায় দেখতেই যাবে
পঁয়তাল্লিশ বছর আগেকার কথা 55 56 57 58 59 61 62 53 54 55 56 57 58 59 70 71
এবার একবার 21 থেকে ডাকো ফাইলটা একবার দাও ফার্স্ট ফাইলটা দাও তো একটু খুলে দাও না
Madam, applications will not be taken up.
Yes. Just 10 minutes, 10 minutes.
Madam.
One appears on behalf of the appellants.
Either of them.
And no accommodation has been sought. The appellant the connected application are accordingly dismissed for default. Interim order, stands vacated.
নেটওয়ার্ক কি এটা বলে দেবে
লিস্টে আছে তো বাড়িয়ে তো তুই অ্যাপেলেন্ট তুই একটু চেক past হয়ে যাবে
22
সেম 23. Same.
24.
Same.
25.
Same.
26.
Same.
27.
Same.
29. 30.
Same.
31. 32.
Same.
33.
Same.
34. 35. 36. 37. 38. 39. 40. 41. 42. 44. 45. 46. 46. 47. 48.
বাস ঠিক আছে এই দিতে পরে পরের
রুল এখানে দিয়ে দিচ্ছে
রুল ইস্যু চেক করতে হবে
না না যে লিডিয়ার নাম্বার করেছিল
দেখি ওই ফার্স্ট ফাইলটা দাও তো
রুল ইফ এনি বি ডিসচার্জ লিডিয়ার নাম্বারটা করেছিল
এটা রুল ইস্যু interim order if any interim order
number 3
one of the applicant has been added as a party respondent. And I still can file propositions. I have filed the Page 104 is the order under challenge.
Yes.
Now your lordship, for the first parent candidate, two writ petition was filed initially, one by the school authority, another by the candidate. Now, my lord,
Which order was challenged by the school authority? The order by which the interview was cancelled.
cancelled initial. But there are two orders of the district inspector schools. Initial, my lord, the school authority came to this court, and if your lordship kindly turn page 80. Page 80.
School came.
School came.
Rajesh Das and others.
Rajesh Das is the president of the managing committee, and the others.
So they challenged the cancellation memo.
Initial. It is not that.
Was that memo against which this was?
Madam, I'm coming. Your lordship kindly page 80. Let me start from the very beginning. In paragraph 7 of the said affidavit, names of the eligible teachers are disclosed who can apply and participate in the selection process for filling up the post of assistant headmaster of Chandrabedi High School, District Paschim Medinipur. Previously, a date was fixed on 13 December 2024 for holding interview for filling up the post of assistant headmaster in the said school. But the eligible teachers of the said school made a complaint before the concerned district inspector school, Medinipur, on 2nd December 2024. Consequently, the concerned District Inspector School issued a memo on 6 December 2024 forwarding the complaint to the teacher in charge of the said school. It is submitted that Mr. Kamalesh Bhattacharya, Learned Council, appeared to the petitioner that due to memo of 6 December 2024, the complaint lodged by the eligible teachers interview could not be held on 13 December 2024. Today, it is submitted on behalf of the petitioner for a fixation of the date for holding interview for filling up the post of assistant headmaster of the said school, when all the eligible teachers shall be permitted to participate in the interview. In view of such submission made on behalf of the petitioner who are of the office bearers of the managing committee of the said school, District Inspector School AC Paschim Medinipur, being the respondent number 3, is directed to fix up a date of interview by 7 days from the date of communication of this order. After the date to be fixed by the concerned District Inspector Schools, said the school authorities shall publish a notice granting adequate opportunity to all the eligible teachers to participate in the interview on the date of the fixed by the concerned District Inspector Schools. Adequate time shall be provided to the eligible teachers to apply by submitting their candidates in terms of the date to fixed by the concerned District Inspector School. Interview shall be held shall be conducted by the school authority in accordance with law, and a panel shall be prepared and to be submitted before the concerned District Inspector School for taking a decision. District Inspector School is directed to supervise the entire selection process in order to bring the same the logical conclusion with the appropriate direction the petition stand disposed of. Now, my lord, the in terms of thereof, the after disposal of the writ petition, your lordships kindly page 87. Well, a notice was served.
No, the earlier date of 13 December 20.
Well, that is cancelled, postponed. Well,
no one appeared in that.
Yes, 13 December interview cancelled. So there is no question, because before that I came to the court, school authority came to the court, court said you fix up the further date. Further date with the supervision of the DI. Now your lordships kindly in terms of the order passed by the court, the steps have been taken, page 87. In compliance with the solemn order of the Honorable Kolkata High Court, such and such order of the Honorable District Inspector of Schools, Medinipur, by the letter number such and such, the undersigned invites application for the post of assistant headmaster of the school from the approved willing teachers who are graduate with honors, including special honors, or holding master degree with 2 years from course and having at least 5 years teaching experience in high school, high madrasa, holding a regular BT, BEd, PGBT degree. Application with full biodata along with the mark sheet and certificates of all examination with caste certificate should be submitted to the undersigned before 2/4/2025. Now, my lord, this is the signature of the teachers. In next page, the notice it was pasted, and call letter of the interview it was given one after another. It starts from the page 89.
17th April 25 date.
Was the date fixed? Now, my lord, on 16th April, after
So all the notices were received prior to 16th April.
Prior to 16th. Now, your lordships kindly have a look to the impugned order, which order is under challenge, page 10, 102.
Postponement.
Page 57.
Postponement.
Page 57.
Page 57.
Page
57.
What which one? There you go.
Oh, this is secretary.
No, letter of the DI.
57, my lord. 57 annex to the stay application.
16th April.
16th April.
Memo number law 103.
There is 1 day prior to this.
Yes.
1 day prior. The interview that was scheduled on 17th
was postponed. And 16,
the letter came after. Where is that postponement of?
Second, on the third paragraph, part, steps part, the last line of that paragraph, scheduled to be held on Sunday is hereby postponed. This notice, the managing committee received this. On the very next page, that's the response from the managing committee on the self-same date.
So this
now,
respect of-
assistant headmaster, in respect of in respect of the teaching staff of the only schools, the post of the headmaster, assistant headmaster, candidates are the teaching staffs who have got the same schools. It is not the advertisement, employment exchange, these are not there.
Yes.
Now, my lord, immediately.
This memo was challenged by you also.
School
were a participant in the
I secured first position in the panel
prepared
on 17th April.
Which was postponed.
Which was postponed 17th April, and the school authority also
So
filed.
you also challenged this.
I also challenge, school also challenge.
Right.
Now your lordships kindly see
Without postponing the same.
the
3%.
on 16th
But
April.
school authority, without postponing the same, held the interview in which 3%, three teachers
Yes,
only
yes,
participated.
yes, out of 10.
It is the fact.
Yes, yes,
In
yes.
16th April, in the 17th April, how many persons appeared?
Only 3. Only 3 persons appeared.
10 candidates were there, only 3 appeared.
Now your lordships kindly see the reply. Next page, page 58. Next page, page 58. With reference to the above mentioned, I would like to inform you that the 10 teachers have applied for the post of AHM and none of them belong to the panel of 2016, which has been cancelled by the Honorable Supreme Court. Hence, I think there is no reason to postpone the interview, which is scheduled to be held on 11 a.m. 17/4/2025. I therefore request you to kind enough to grant me permission to hold the interview, attached here with the approval copies of the all application of the kind perusal. An interview was held, panel was prepared, and same thing.
A permission granted?
No, permission is not required at all. We said so.
So why
now what is
why
the
you are seeking?
that
Why
my
you are
lord,
sought?
that now your lordships kindly see the what the rule says.
Now, in the 17th April interview, you participated.
Yes.
And you stood for.
I used.
Then why you are challenging?
Well, the cancellation. This is the order of the single judge.
After this panel was prepared.
Yes, it was submitted. It was submitted before the district inspector schools. My lord, now I came before this court challenging the order of the cancellation of the district inspector school.
Did the DI take any?
No. Now the learned single judge said no, they hold the fresh interview. This was my submissions. It is if the panel is prepared, the DI will take decision of whether it is accordance with law, whether the lack of qualifications, whether there is a dispute, whether there is a complaint. When, my lord, the DI has no authority to pass an order for postponement of the interview. That was the subject matter of the challenge. So,
Same school.
Same schools. This is the rule says that once the date of interview is fixed, it cannot be postponed without the severe emergency or natural calamity. This is the only 2 lines it has been said in the recruitment rules. page 54, your lordships kindly have a look.
Mr. Badi, if
Yes.
that is your argument. Go to the DI, let the DI take.
Yes, no problem.
Page 61 is the DI response.
Now I shall be placing the rules.
No, before the rules, page 57, what is the Supreme Court order?
Nothing. This is the, my lord, very beginning, the DI was citing a
Supreme
particular
Court's
group.
order,
Is
26,000
making-
matters.
Making politics. But on 3rd April 2016, the Supreme Court passed an order en bloc cancelling entire selection process of 2016. On assumption, DI passed an order. No. There is a Supreme Court direction.
That is fast SLST. That
Yes.
is
Nothing. But what can be done? The DI intentionally, he is directed.
teachers who are appointed.
But this is, can it be? It is the DI, if it is prepared by the selectors. Now the DI will check up. No problem. Whether the 16 candidates are there in this ground, entire panel may be cancelled. But can the DI direct for postponement of the interview? On the basis, no, Supreme Court passed in 2016, entire selection, you hold the interview, we postpone the interview.
Confirms that they are.
Yes, immediately on the day. And
Candidate of panel of 2000.
yes, and when the school received 235, when the less than 24 hours.
Permission चाहिए school authority के can be permission सुप्रीम permission directed to DI to supervise. DI says postpone it. Let me know.
Yes, next.
Next, my lord, your lordships kindly have a look to the recruitment rules. Page 50. Page 54 is the page 53, the type copy. Page 54, clause 5.
Page 15.
4.
During a panel. I should submit.
Once the date of interview for the post of assistant headmaster or assistant administrator has been fixed up, and communication to any of the candidates, the interview shall not be postponed except under severe emergency or natural calamity, and the facts shall be communicated to the district inspector school forthwith.
There were two reasons: natural calamity and severe emergency.
Yes. Now, my lord, I shall be placing the affidavit in opposition filed by them. The
Who are the
affidavit in opposition filed by the DI. I reply to the would reply
opposition opponent number 3.
3.
স্বপন সামন্ত স্বপন সামন্ত
একটা কপি আছে না?
In all such cases, approval of the TI, but no case shall be obtained for holding open interview on it.
সুপ্রিয়তা তোমাকে রিপ্লাই কপি দেওয়া হয়েছে?
এই পোস্টপোন হয়, পোস্টপোন ইন্টারভিউ নিতে গেলে ওরা আবার পারমিশন দেয়। কি বলবো?
Now, my lord, the DI says there are 3 onwards. They narrated the fact. The school authority fixed up the date of interview for filling up the post of assistant master in Chandra High School to be on 13/12/2024. On 2/12/2004, 15 teachers and others submitted the joint representations before the office of the alleging the last date of submission of the application for the said post was 3/12/24. They are not allowed to submit their application till 2/12/2024. They requested appropriate steps so that the candidate could also be considered and could fairly participate in the said interview. The copy of the representations is annexed here. Considering the said representation, this office by memo number 30772/12/2004, memo number 31206/12 for maintaining transparency directed the school authority to postpone the interview, and they had been scheduled on 13/12/2024. Your lordships kindly see the representation received by the district inspector schools on page 12. Page 12. I have never seen that so prompt action of the DI, particular district. Page 12 is the representations of some teachers. What is the representation? Amra Chandra Uchcho Bidyalaya Shikkok Brindo বিনীতভাবে জানাচ্ছি গত বেশ কিছুদিন যাবত বিদ্যালয়ের টিআইসি ম্যানেজিং কমিটি যৌথভাবে শিক্ষক শিক্ষার্থীদের বিভিন্নভাবে অপমান ও ব্যক্তিগতভাবে মানসিক নির্যাতন অসম্মানিত করছে। এইরকম পরিস্থিতিতে টিআইসি গত 26/11/2000 তারিখে অ্যাসিস্ট্যান্ট মাস্টার নিয়োগের বিজ্ঞপ্তি প্রকাশ করেন। বিদ্যালয়ের টিআইসি বর্তমান পরিচালনা সমিতির সাথে যুক্ত হলে যেন তেন প্রকারণে ওনাদের নিজেদের লক্ষ্য এইচএম পদে বসানোর জন্য বিদ্যালয়ে আতঙ্কের পরিবেশ তৈরি করছেন। আমরা যারা অ্যাপ্রুভ টিচার রয়েছিলাম ওই পদে অ্যাপ্লিকেশন দ্বিধাগ্রস্ত আছি। অ্যাপ্লিকেশন জমা দেওয়ার লাস্ট ডেট 3/12/2000 হলেও 2/12/2005 আমরা কেউই অ্যাপ্লিকেশন জমা দিতে পারিনি। তাই উক্ত নিয়োগ প্রক্রিয়া যা সম্পূর্ণ স্বাভাবিকভাবে হবে সেটা আমরা আশা করতে পারছি না। তাই আমাদের নিবেদন এই যে আপনি যদি চান্দ্রা উচ্চ বিদ্যালয়ে এই যে নিয়োগ প্রক্রিয়া বিদ্যালয়ের পরিস্থিতি স্বাভাবিক হওয়ার পর করেন তাহলে শিক্ষক শিক্ষিকা শিক্ষাকর্মীদের বিদ্যালয়ের পরিবেশের পক্ষে ভালোভাবে হবে বলে আমি আশঙ্কা রাখছি। Immediately on 2nd December, it was received by the office of the district inspector schools, and while the district inspector schools immediately prompt and DI wrote a letter.
That is not the subject matter.
No, earlier I was submitting the particular group with the collision with the DI. This is not a first time. Had it been a first, no problem. It is on 13th, it was scheduled. 13th was directed to be postponed. 2nd December, the representation was made that we have not been allowed to deposit the form. Very well. On 2nd December, after receiving, within an hour, the district inspector schools, took a steps. However, that cancel everything was there. Now, by the order of the court on 17th April, the same thing happened. Same teachers. Now, they are present in the school on that particular day. They will not participate in the interview. No participation, no problem. You have chosen not to participate, not to participate. Then, my lord, immediately interview was held, and rule says even less than 3% the panel can be prepared.
But before that, Mr. Badi, page 8, the rules which you have put us just now. Page 85.
Page 85.
The rule you showed us.
54. 54.
50.
Yeah. 54.
Please read clause 5 again. Once the data of a poster is fixed up and communicated to any of the candidates,
Yes.
the interview shall not be postponed.
Right.
Except under
Severe emergency and natural calamity.
That shall be communicated to the DI.
Yes.
In all such cases, approval of DI, but no fresh prior permission shall be obtained.
Right.
So
school did not postpone the interview. It is the DI postponed the interview.
No.
Yes. Your lordship, kindly have a look to this.
The interview was initially postponed on 13.
13, thereafter 17.
It is 17.
13.
So it is.
Let me clarify.
It is a postponed interview.
13th was challenged by the order of the court. Again, date was fixed on 17th by the order of the court. That 17th was postponed under the order, not postponed. The district inspector school passed an order directing the school authority to postpone the interview less than 24 hours before. Then the school authority did not. The school authority held the interview and prepared the panel and submitted the panel.
Suppose postponement was by the DI.
Yes.
And you come to the school letter, page 58.
Page?
58.
58.
16th April, school writes.
Yes.
That with reference to our like to inform 10 teachers applied, none of them belong to 2006.
Yes.
Hence, I think no reason to postpone. I would request them to kindly grant me permission.
Well, not permission is required. Maybe writing is different. Permission is not required. Permission. Well, rule says. What is the rule says? Your lordship, kindly have a look to the rule again. Once the date of interview for the post of assistant headmaster has been fixed up and communicated to any of the candidates, the interview shall not be postponed except severe as a natural calamity, and the fact shall be communicated to DI of the schools. I have not, but this postponement was not made by the school authority. The question of communication to the DI doesn't arise because the DI himself is communicating. You postpone the interview. I challenge that legality. The way that the DI could do this. Where is the power of the DI? Under what circumstances DI can do this? I have showed the rule 5. Then when the latter single judge said, no, that may be a further occasions you hold a fresh interview. Why should I hold a fresh interview? When my lord I appear, entire thing is completed. It is for the DI who can take a decision in respect of the panel. Whether the teachers are qualified, whether the 16 untended.
Mr. Bari, yes. When you have participated in the interview,
Yes.
you have accepted the learned single judge order to some extent.
Right.
What you have accepted, that a fresh interview will be held.
Yes.
And that would be held under the supervision of the
DI. Whether
you have accepted that
yes,
part,
now,
up to that part.
Now.
Whether it will be
Yes.
postponed or not, that is latter part.
Yes.
Up to this part, you accepted the order of the learned single
Right.
judge. And accordingly, you participated.
Yes.
So there is this fact that the interview will be held
extremely
under the supervision of the
DI of the school.
So DI must have something to say.
Right.
They must have a say.
Right. Extremely grateful. Well, right. Now paragraph 10 of the judgment, 109. Paragraph 10 of the judgment, 109. The DI did not prefer an appeal against this observation. In terms of the order dated 25th February 2025, when the respondent number 3 fixed the date of interview via memo number 19th March 2025 on 17th April 2025, taking note of the fact the said school authority issued notices to all the teaching staffs and the school, thereby extending due opportunity to all the candidates to offer their candidate. It is found not proper on the part of the respondent number 3 to postpone the interview scheduled on 17th April 2025, issuing the impugned memo 16th April 2025, just 24 hours before, when all preparation were complete from the end of the said school authority to conduct the interview. It transpired that respondent number 3 has misread the observation made in order dated 25th February 2025, permitting the said respondent to supervise the selection process and took such steps memo dated 16th April, which was not warranted. Only requirement was fixation of date by the respondent number 3 in terms of the order dated 25th February 2025 for holding interview and to see whether eligible candidates were given due opportunity or not by issuance of the notice by the said school authority prior to holding of such interview. It also appears that the said school authority by letter dated 16th April clarified the response to the impugned memo 16th April that none of the 10 teachers who applied for the post of assistant headmaster was appointed based on selection process past SLST 2016. Hence, memo dated 16th April 2025 stands set aside. That memo, what was passed by the DI was set aside. Next paragraph. However, panel was prepared on basis of the interview dated 17th April 2000 or not to be given effect to, since it is found the letter dated 16th April 2000 is a teacher in charge that though 10 eligible candidates applied for the post of assistant master pursuant to the notice issued by the school authority, but only 3 candidates participated in the interview held on 17th April, there might be certain reason for absence of 7 eligible candidates in the 17th.
Postponement was bad.
Yes, and it is cancelled.
Now,
then what remains?
Next rider which wait with the
panel will be disposed of in accordance with law.
rider says.
But that is I am agreed.
Only 3 persons have participated.
But merely 1 person's. Even one persons can appear in spite of notice to everybody. It is nobody is the case that we have not received the notice.
Yes.
So show my lord, these portions. The learned judge was of the view this is the decision of the DI is bad. They have accepted that. There no challenge was thrown against that order. When this portion of the order of the DI is set aside, then what remains? Then my lord, panel is required to be disposed of by the DI. The formalities, whether the notices were properly served, whether these tented candidates or the candidates of selection process was there, whether all formalities in terms of the rule were complied or not. Let them.
Proper story. 10 persons were the participants. Other 7 did not
participate. My lord, even notice your lordship knows the Tondramondol case, Calcutta 1996 CLJ. Even 1 person.
No,
is
saying that what is the actual reason why these 7.
But the group. You are holding the interview, this managing committee. Now the managing committee is changed. Now the managing committee is coming on next month. Why I should appear in the under this managing committee? Now I will now definitely the managing committee is changing his color, although under the rules they cannot, because they have took a decisions to file the action of the district inspector schools. Now he cannot change the color. To show this is the reason internal group. Why? Why they? If they why chosen not to participate?
Mr. Badi, are you agreeable to this? That your panel preparation will be for approval if you go to DI?
It has already been submitted.
But we will make it clear that we will consider the effect of non-participation of 7 candidates.
No, if your
point of it,
no problem. But your lordship kindly clarify. In spite of notice, if they have not appeared.
No.
We will only
The restoration is to restore it.
Mr. Badi's contention, state has not preferred appeal. Postponement was one hand bad.
Yes.
Court has wanted that there should be pre-circulation, all must participate. It is one school, competent person should not be left. So court will, the DI, we will send it to the DI.
Yes.
But I will say that before approving the panel, you have to see whether all the persons
are properly served or not.
Non-participation of all of it.
No, madam, I have received your lordship kindly visualize. I have received the notice. I have decided not to participate. Whether the court can force me. That
they were under the impression that
not impression, the question of impression, assumption. Yes.
If I had been the interviewee,
yes.
Somebody has told me tomorrow you have to appear. I find DI has issued a letter.
That
was in my favor.
If I think there is an interview that will be held by the particular group of the political party, I will not appear. Can it be the ground of challenge? Because the interview date was, if it is not circulated, if you have not received the notice, the question would have been otherwise. You were present in the school. You have decided not to appear because I will not appear in the
Okay.
interview.
But Mr. Bari, from another angle, you think that one thing is bad.
Yes.
And hence it is set aside.
Right. Then,
But
madam,
since it has bad, it has caused certain harm. And then doctrine of restoration will come.
Yes.
That the person who has suffered harm, they
Madam,
should be given
they are not coming before.
some
Madam,
restoration.
they have not challenged that.
This is my case, ma'am.
They have not challenged that.
This is exactly.
Simply, yes.
Whatever DI has done, it is bad.
Yes. Madam, then what
But
remains?
that action of the DI has caused certain harm to certain person.
Madam, what
So
remains?
they are entitled to get benefit of
100%. But if they've chosen not to appear, the DI will see whether they have voluntarily decided that they will not appear in the interview. DI will check up. No problem. If I am in the schools, I have decided, no, you are holding the interview, I will not participate. For this reason, entire panel will go. I am putting myself this question.
Yes, who is opposite?
Now, I
am.
will address because it is his. And my lord, if your lordships kindly, allow me 1 minute time to affidavit reply to place my affidavit reply.
তুই তো বলে দিয়েছি আমারগুলো আর কিছু বলা আছে
Your lordships kindly affidavit reply, your lordships kindly consider. Lordship got it? Affidavit reply, yes. Page 2, para 3, it starts. Before dealing with the opposition of the respondent number 3, I write as follows. That on 2nd December 2024, on the basis of the complaint letter, 14 teachers, 1 non-teaching staff, respondent district inspector school sent an incomplete order of the postponement of the recruitment process. Just on the next day, the 3 teachers and among the above 14 teachers submitted their candidature. Copy of the document submitted the candidate annexed thereto. School authority sent the district inspector schools the reply on 14/12/2004, continued the process. On 16/12/2024, on the basis of the same complaint letter, district inspector school again postponed the process of without any verification or any inquiry about the complaint letter till the repetition by the school authority. Malad, a complaint can be made at any point of time. I have received a complaint. You are directing not to hold the interview without any reason, without any inquiry, without any verification, nothing. I have received a complaint. Every day, my lord, your lordships are receiving the complaint. That means, my lord, we shall take and come.
It is regarding the earlier interview.
Yes, yes.
Now next,
Then I'll
come to next.
In the order of the Honorable High Court dated 25/2, it was ordered the DI to fix up a date interview, para 5, my lord, by 7 days from the communication that order. DI received the copy on 3/3/2025, but he did not communicate any till 18/3/2005. On 19/3/2005, District Inspector School sent a letter through mail fixing a date of interview on 17th April with the guideline of interview process to the school authority. The school authority maintained all the guidelines of the District Inspector School as well as government recruitment rule of AHM and informed the DI to time copy of the guidelines annexed thereto. On 16/4/2005, 2:35 p.m., DI has sent a letter through mail ordering to postpone the interview on the basis of the Honorable Supreme Court order about the recruitment through first SLST 2016 panel. He wanted to know if there is any applicant from the panel. Honorable Supreme Court passed an order on 3rd April 2025. The scrutiny committee sent their report all about the applicant for the post of AHM on 7th April. Yet that order for the postponement just previous day. Well, we have sent the scrutiny report that we have verified, scrutinized everything. And that Supreme Court order was passed on 3rd April. 16th April, the DI communicating this order after 2 weeks.
What was the matter which went up to Supreme Court?
That matters cancellation of the entire 2016 selection process. Tainted candidate, untainted candidate, none of there. These teachers, none of that category. And we have said so, communicated that. The school authority submitted the report again with supporting documents on the same day, 16/4. Yet District Inspector School did not change his order because he was determined not to recruit the post till the end of the term of the managing committee. School authority did not have enough time to conduct MC meeting about postponement of the interview and also wanted not to violate the recruitment geo number such and such, hence conducted the interview on 17th April 2025. On 17th April, 3 applicants faced the interview. Through other 6 applicants were present at the school. They did not face the interview to disrupt the inter-selection process, and 1 applicant was absent that day.
How many applied? How many?
12 applied. Out of 12, 10 were found as eligible to participate. Yes.
The school authority submitted the panel.
And 3 persons appeared.
Right.
So 7 persons.
3% the panel is prepared, 3% appeared.
7% were the other applicants.
Other applicants. Now the school authority submitted the panel on 21st April 2025 to the DI for approval. According to the DI of the schools, has to approve the panel and to give any remarks within 1 month from the date of submission, but it did not do so. Copy of the panel is annexed here. On 5/6/2025, after several requests from the school authority, district inspector school sent some baseless query on panel through email. The school authority submitted the answer of the query on 9/6/2000 with documents. Then again on 26/2002 sent a letter seeking some unnecessary papers.
He will when the DI will consider the question of approval of panel, but we will mention that he takes such decision after giving hearing to all the persons who did not appear. What Mr. Bari says, one thing is that if this fact situation was not there, in a general case, you give me a chance to appear. I do not appear. It is not that I have to mention the reason why I am not. I can choose not to appear.
Yes.
So if the confusion, for that confusion, the single judge said that you do this. So when the panel has been prepared, school is before us, we will let the DI take a decision on the entire aspect. And if the DI upon hearing finds that no, those 7 persons willingly chose not to appear, because that rider of postponement of interview given by the DI was not interviewed.
That part is not applicable.
No, that will not. We will simply relegate it to the DI.
Yes, but postponement, that postponement is by the school authority, not by the DI. Don't you kindly go through clause 5, rule 5.
That's a restriction on the managing.
That's a restriction on the
managing committee not to postpone, right?
Yes.
They can postpone.
Yes.
But they can postpone due to A, B, C, D, E reason, maybe. The postponement power is with you. We simply relegate it. This is the
Mr. Jana Klein-Mallard on that date.
DI fixed the interview, DI postponed the interview. DI fixed the interview because as per the direction of the
Bol na, to date na সেই দিন।
then 2
47%.
Yes, ma'am.
One of the
Yes.
Yes.
Out. Within 7%.
No, he also.
I represent, my lord, 5 of the 7%.
Oh, 5, I need
And
2.
One. Mr. Jana is one, he is five.
6. Another my lord, now appointed as teacher in charge because headmaster is here. Now my lord, there is no assistant headmaster or headmaster.
So I just.
There are 7 remaining 3% in panel. First, second,
3.
and the remaining is
7.
because there were total 12. What did you say? 10.
Total 12, 10 found eligible.
10 found eligible. He was found eligible in the prior interview also.
No. In terms of the fresh.
Press interview.
Madam, may I just. My lord, my application already allowed, my lord. I'm already added as parties here. I just tell your lordship, my lord, I have, my lord, only 2 things to submit to your lordship. I have, my lord.
One of the persons who did not appear.
Did not. My lord, which, my lord, troubled your lordship, my lord, subject to lordship's correction, my lord. What is the reason for which we did not participate? Whether that is, my lord, at all, my lord, believable of what we are right now addressing to your lordship, that because of the DI's order, I did not participate. My lord, kindly sees the affidavit in opposition used by the state. Kindly sees one document. My lord, which is affirmed, my lord, on 14th of November 2025. Yes, that one. My lord, may I request your lordship, my lord, to see, my lord, paragraph, page number 19. My lord, yes. So here your lordship will see the date. Yes, ma'am. Yes. So my lordship sees the date. It is 17th April 2025.
Date of the
Interview. Or what do we write, my lord?
Read.
Or we say, আমরা এই সাচান সাজ উচ্চ বিদ্যালয় সাচান সাজ হচ্ছে আমাদের বিদ্যালয়ের অ্যাসিস্ট্যান্ট হেডমাস্টার নিয়োগে ইন্টারভিউ আছে আজ, অর্থাৎ 27 তারিখে হওয়ার কথা ছিল। বিশ্বস্ত সূত্রে আমরা জানতে পেরেছি যে আমাদের বিদ্যালয়ের ইমেল মারফত বিদ্যালয়ের টিআইসি কে উক্ত ইন্টারভিউ অর্থাৎ AHM প্রক্রিয়া স্থগিত রাখতে বলেছিলেন। নিয়োগ প্রক্রিয়া স্থগিতের নির্দেশ আপনি দেওয়া সত্ত্বেও বিদ্যালয় কর্তৃপক্ষ এবং টিআইসি মিলে AHM নিয়োগ প্রক্রিয়া ইন্টারভিউ নিয়ে নেন। আপনার এই নির্দেশ জানার পরে আমরা যারা AHM এর নিয়োগের জন্য আবেদনকারী ছিলাম তারা কেউই এই নিয়োগ প্রক্রিয়ায় অংশগ্রহণ করিনি। তাই আমরা মনে করি এই নিয়োগ প্রক্রিয়া সম্পূর্ণরূপে বেআইনি এবং অবৈধ। আমরা বিনীতভাবে নিবেদন যে যথাযথ ব্যবস্থা গ্রহণ করে আমাকে বাধিত করুন। So my lord, I just submit to your lordship, my lord, which has already fallen from my lords. My lord, here I do not, my lord, make any submission about whether the DI was right or DI was wrong. My lord, the problem that I am here facing, my lord, I have, my lord, the complete confidence on the DI because of the by dint of the honorable court's order. Apart from the power of the DI being intrinsic on the rule, my lord, the honorable court directs the DI to supervise. So my lord, since the DI has got the authority to supervise, the DI itself says that you do not conduct the interview tomorrow. My lord, we do not participate and we write the letters to the DI. Now, I'm sorry, my lord, what I just trying to say, my lord. Now, my lord, it is said by the honorable court itself that that particular letter was wrong. But my lord, what wrong did we commit? Because we were on the belief that the DI has got the authority to supervise over our entire AHM process, recruitment process. So my lord, that the DI specifically says that you do not conduct the interview. We do not go into the interview.
Found to be bad by the single.
But my question, I was asking this question to myself.
Petitioner or imputed
No.
Coming to us now. This is my predicament.
Yes.
Somebody else gets the appointment upon approval of panel.
Yes. For the.
You are not giving me any opportunity to
Yes.
say this which you are saying to this court.
Yes, my lord. At the same time, we were what is right now being proposed from this honorable court, my lord. If my lord, that happens, if the district inspector, my lord, decides that we cannot, my lord, participate in the examination, my lord, in that event, my lord, we will be suffering for no fault on our part. But I just
stalemate.
My lord, I subject to correction, my lord, on the very. I will be, my lord, because if the district inspector now comes and says that yes, and also, my lord, I could not find out any single submission from my learned senior why the observation of the honorable single bench was wrong. by saying that you conduct, since this is the situation that has been created by the DI. I set aside DI's direction. Since people did not get the opportunity, so let them get the opportunity. I do not find, my lord, it's subject to lordship's correction. My learned senior friend has pointed out any illegality in the order.
Right, Mr. Roy, a little extent also, it is like a chamber game. I have, from that process, I have stood first. He has stood first.
Or he will be standing first in that event.
Also be having an expectation that I should also be heard. Like,
yes.
Your problems.
Yes.
Today, when I have appeared, I have succeeded. I am in the first position.
Yes.
Irrespective of managing committee constitution and everything. Today we are on 12th of.
Yes, ma'am.
11th of.
Yes. Yes.
If the new managing committee comes, what is being
But yes.
by whoever will be the committee will be
But
heard.
yes, but if the interview, my lord, is taken place, if they
And we will say that the decision will be taken.
But yes, but they can immediately just appear in the interview, and all of us, let us all. I'm so sorry.
for experience and 5
Yes,
for
yes, total 40. Total 40, 35.
No, no, 40 to 9.
Mr. Police for this school.
For the school.
So where is your resolution according to and panel?
ঠিক আছে।
That is not there.
So can you score sheet can you show your evaluation?
Not here, madam. But may I submit one thing, if your lordship permits me? In compliance with court's order, a date was fixed, the date of interview was fixed by the DI. Now, for some reason, DI, my lord,
Postponing.
DI postponed. There was no request from the DI to postpone. Now, on the
Cancellation is not by the school.
not by the school. Now, why I'm saying this? So on 17th.
Like if cancellation was by you, you ought to have taken another permission.
Yes. Yes.
But in your letter, you wrote
Yes.
that I am taking permission.
Yes. Now, what happened on 17th? On 17th, the order of DI that was in existence, 16th April, it says the interview dated 17th is postponed. So we had no occasion to hold it.
Fantastic submissions.
Yes.
Mala, he had challenged. No, your lordship, kindly allow me 1 minute. The school authority challenged the same. Can you take the somersault today?
But I have to say the legal situation.
Due to changing of the managing committee.
But the change of your color. Now, he was so powerful. Mr. Bari's client was so powerful. The school authority, knowing it well that there is an order restraining by the DI, they hold the interview with only those 3 persons, excluding 7 others.
It was your fault, sir.
Yes.
Yes. That's the situation. That's the situation. Now, out of 10, only 3 were there. Why? Because
that you did not tell the court that there was this pressure, that pressure, very powerful influence.
ultimately the single
he
bench
challenged the
which
same.
had appeal before
The
Lord
school authority challenged the action of the
voted
DI.
of opinion that out of 10 only 3 appeared and 7 did not or could not. So, my lord, for the sake of interest of education, let a fair play be there. The selection process will let the finest person
Fantastic,
come.
fantastic. Rajesh Das was the president of the managing committee, filed a writ petition. New managing committee came and he's changing his color.
Yes. Let the fittest person come. If a fresh interview is held, my lord, we believe the fittest person will come. But that is the erstwhile management. That is the erstwhile managing committee.
Oh, you are the new.
Yes, yes, and they were managed.
May I submit one thing?
Managed.
May I submit?
Citing legality, you're arguing legal.
Yes.
The question is that this has separate pedestals. Now, fact-finding issue we cannot consider. We will relegate it to the DI. We will point-wise indicate that these points we will consider.
As on date, before your lordships, our representation is there. The person said on 17th, we didn't appear due to this order of DI. What else is to be decided by the DI, which has been annexed in the with the affidavit in opposition by the state?
Madam,
this is before lordship.
Madam, this order of
16th memo of 16th confusion, and due to that 7% didn't appear.
Madam, may I submit one thing?
Hello?
Say
Yes.
that memo of
Is illegal.
not sustainable.
Not sustainable, but due to that illegality, 7% couldn't appear. That's also been accepted by the court, and that's the reason there is a direction for fresh interview.
Yes.
And I could not appear because
Why
I
he is
was
so
not
shy?
made by the
He knows it well.
Madam,
The need of selection
Council of Higher
is there.
Secondary
You would
Education.
not be the
Yes,
fittest
please
person.
come today.
Madam, may I submit one thing?
Even 5 out of 5
That
is given, he
decision-
would not be selected. If 5 out of 5 is given, he would not be selected. That is his predicament. That's the reason he is so vocal. And we are going to get a lesser, ICMR, the lesser eligible person as a assistant headmaster. And what selection doesn't confer any right to him.
You yourself said that I am not postponed.
Yes, yes.
Disobey your order.
Yes.
You
Yes,
said-
yes.
Now you are.
No,
coming on
I'm
the
telling the
basis
fact
of-
before Lord.
You ought to have obeyed that.
Yes. The law says so. Why all these things happen? Why
Law
illegalities?
would have been so had there been no change of this stand. Now then, every matter, everything a decision taken by me. When in my place another person comes, another.
Now, but what we did, we have accepted the order of the single bench, and we say let there be a fresh interview so that we can get
Madam,
up.
Only one thing, Madam, may just answer to your.
Not within 10, not within 3 odd. Let it be out of 10.
The decision of the DI
Satisfy us.
Yes. Madam, fast, Madam, I tell you. Madam, the decision of the DI.
Before my learner senior Madam says, if I just could answer your lordship's query about the what prejudice that I suffered here, what has been proposed from your lordship, if it's,
You have chosen.
if I just could satisfy your lordship, but if I am right now, these entire things are being relegated to the DI only on the point why I did not appear on that particular date. My lord, our merit will never be, my lord, adjudicated upon. Only, my lord, the fact will be adjudicated upon whether this non-presence of the persons are right or wrong. My respectful submission before your lordship, since our action, my lord, was completely based upon the order of this honorable court, that since whatever the DI will be doing, we will be following that. So, my lord, we should not be blamed for this. And, my lord, if somehow the decision goes against us before the DI, then we will be already losing the, my lord, forum of judicial review of both these honorable courts. By then.
Yes.
Now, my lord, the twofold submission I'm making. This decision of the DI was never communicated to anybody other than the school authority. On 16th, 4:30 p.m., that interview, this communication was made to the school authority, not to anybody. They are so knowledgeable. The DI said, so we shall not appear. Huh? Well, through email. Through email to the school authority, it was communicated by the office of the DI. It was never circulated. It was never communicated to any of the body. The school authority only received that communications. And the school authority said that not, we ignored that same. Everything was done. Less than 24 hours, we have been served with the notice by the DI. We will not the A, we will hold the interview. Then immediately I challenge. Madam, first. Secondly, my lord, in spite of presence of the schools, It is not a fact that the DI has passed an order, it will not be carried out, so we shall not appear. It is your decisions. You have not appeared before the managing committee. And that's why the court will, the interview will postpone on the basis of the DI orders. The legality is being challenged. So, my lord, your lordship, every day in the School Service Commission, when the last date was given, my lord, we are deprived from appearing in the interview. We are coming before the court. Court said no. When last date is given, you will not be permitted, in spite of your all eligibility criteria. Hardly the stand of Mr. Jahan today, well, I have the authority, he cannot do that. The school authority itself challenged the decision of the district inspector schools. Today, he cannot change the color unless the decision of the earlier decisions, by adopting the regulations, the earlier decision was wrong and fresh decision is taken. Let him produce that decisions that the earlier decision was wrong. So we shall not prefer an appeal. Whatever it may be, this is the decision of that. Today, when the managing committee came into power, no, we will carry out. He has challenged that same. Been selected. The markings are wrong. They have given the better marks for the choosing candidates.
আমি তো
may not take up your matter. Original side matter you're there, na?
Yes, there was the original side matter at 330 minutes, but the business of the court obviously.
কোনদিন এই কবে দিয়ে দেবো দেখ।
Malad, I hope Malad, my matters will not be taken up, that applications today. 10.
Is your matter, Mr. Ganga?
Item 10, Malad.
In Mr. Bandyopadhyay's matters, I am the respondent writ petitioner.
Just 1 second. We have called the original side matter. Just one.
Solve it.
আর অর্ডার দিয়ে দরকার নেই, ওই দিনকে রেখে দাও। 12 তারিখে সপ্তাহটাতে কোথায় কি ডেট আছে? আছে কোনো ডেট ফিক্স হয়েছে? দেখো না 12 তারিখে আমাদের হ্যাঁ ফিক্স আছে ভাই। না 12 তারিখ ছেড়ে দাও।
reply. My learned friends had given an opposition last time. At least there'll be something on record.
Let the affidavits exchanged by the parties be kept on record. List the matter for further consideration.
My lord, instead of 15, can it be on 16th or 12th?
The next week then.
Or the
Wednesdays.
Or Wednesdays.
22nd or whatever. 22nd.
Is it for further consideration on 22nd January?
Yes, please. In case there's any misapprehension, I'm the petitioner. Although my learned friend took the initiative to the end.
The joint effort will.
No, we have not said so. We have equally realized your standpoint.
Item 10.
কাল করবে না? এপিডিবি তাই ঠিক আছে, তাই বড় তো অর্ডার করি।
10টা ডাক।
সেটাই ভালো।
8 হলো তো 9টা ডেকে দিন মিস্টার ব্যানার্জি। Item number 9, who is there?
I am for the secondary board.
Mr. Badi, can you come tomorrow?
No problem. This writ petition was disposed of at the motion stage. The court is of the view it should be hard on by.
No. That yes, your lordship directed. Yes.
আরে বলতে দাও না।
কেন অন্য কথা বলছিলাম?
So maybe you will say something. That is his right. He can say.
To show my lord, let there be direction for filing affidavit. Only one portion your lordship wanted to know from my learned friend, whether there is any power that the board can delegate the matter to the Commissioner of School Education for transfer any particular persons. That was the query of the court. From
in the writ petition, affidavits were exchanged.
No.
Nothing. Motion stage
This is an order, final order passed in disciplinary proceeding. This is an appellable order, your lordship.
Appellable order.
Lordship.
So on that ground, the writ petition was dismissed.
No, not on that ground.
No. Writ petition that was not taken into consideration. Nothing. Entire disciplinary proceedings was challenged.
No.
No charge sheet, no inquiry officer.
No, everything. Then your lordship, I'll argue the matter, your lordship. Then I'll argue the matter. Page 69, your lordship, that is the order of the final order passed in the disciplinary proceeding.
We become afraid when you say I will argue the matter. Don't terrorize us. Have mercy on us. Present appeal has been preferred.
Shiva, no.
problem. The board passed an order, the trial judge passed an order upon the board. The board my lord passed an order requesting the Commission of School Education to transfer the petitioner. In the meantime, you'll also on hearing the matter after immediately 2 weeks, my lord, no effect shall be given. Then no action has been taken.
On, on last day, my lord, my learned friend showed an instruction that the commissioner have said that as the matter is sub judice.
If it so happens, you come with an application.
No, my lord, 25th September, no step has been taken till date.
No, there is a report, your lordship, which shows by the commissioner.
We will look into it tomorrow. Let it be there. Or Monday, whichever you like. Next Monday.
Monday, your lordship will be here.
Your lordship will.
I have not said that I said not to.
Let them come with the evidence.
I'll file affidavit.
If any action is taken immediately, but
I'll file
mention before your lordship. Or application will be filed. Let them come.
Yes, next. Yes, Mr. Mohan.
Murad, I am appearing for the petitions. Item 10, na?
But I appear for the respondent writ petitioner.
Murad, order impugned is at page 346 of the application for stay.
Any page 200 and?
346.
Order
of the stay petition.
Yes, Mr.
Can I place the case or can I place the judgment?
So, Bandhavadda, you will take some time, na?
Yes, my lord, it will take some time.
Then what do we do? We can keep it on
tomorrow.
Next week I can keep it or
tomorrow. There are so many matters.
On this order, there are other matters wherein the Honorable Court expressed that whatever would happen in this matter, it will be also there in the other matters.
We have to hear it.
True.
Tomorrow
morning.
Tomorrow,
would it be possible to allow?
Let it be next week, Mr. Bandhavadda. Let us see what happens.
Monday I have difficulties. Tuesday. Monday I have difficulties.
All right. Tuesday.
Yes. I'm not.
Heard Mr. Bandhavadda, learned senior advocate, appearing for the appellants, and Mr. Dhar, learned senior advocate, appearing for the writ petitioners, respondents. Stop. List the matter for further consideration under the same heading in the daily supplementary list of this court on 16th December.
16th December.
Yes.
It's all right, madam. I'm deeply obliged.
Yes.
That is another one is the appellant. I am not.
Item number 11. There also sir is leading.
No, I am appealing for the respondent in this.
Respondent, sir is my leader.
Similar.
He is not similar.
Tuesday.
Next week, my lords, perhaps will not be sitting on.
Any one of our brothers will be here. What is the? Mr. Bandhavadda, you are available tomorrow? I don't think, because
tomorrow I can do the matter. Tomorrow I can do the matter.
I can only say this.
Tomorrow I can do the matter.
Next Tuesday করে দাও এই item number 11 টা next Tuesday চল
নামগুলো দিয়ে 11টা 16 তারিখে হচ্ছে বলে দিস
item 11 টা